hearing session pursuant to adjournment that the Constitution is on the court.
Good morning. May the parties make their announcements.
I'm Jonathan Landers, and along with Neil Davis, I represent Mr. Lowry, the appellant.
I'm
Good
Patricia
morning.
for the state.
Good morning.
Good afternoon.
Okay, I understand, Mr. Landers, you want 9 minutes and 6 minutes rebuttal. Is that correct?
Yes, Your Honor.
Okay, let us begin. If you don't mind, Mr. Landers, I've got a couple of yes or no questions.
Okay.
And they are, have any other state courts considered the constitutionality of the statute similar to the section 262? And do any other states have laws against child erotica?
As far as I know, the answer to question one is no. I do know that the Netflix case is pending out in East Texas. And I also spoke with those attorneys, and they actually hadn't even heard of our case until I called them about it. So no. Secondly, I have not done detailed research on that question since we very first started this thing. I have not found any of the state courts that have done anything on child erotica, and not that I've double checked their work, but neither had the law firm on that East Texas case. So.
Okay, so if you are aware, or if you are, that section 262 has been used to prosecute in other cases besides this case, could you send me not including Netflix, like a 1-page, hey, guess what? Same thing for the state. If you find any cases that are outlined in the questions I just gave you, would you please give us a very short summary of what they are? We can look them up ourselves.
Okay.
All right. Let's begin.
Okay. Chief Justice Braddock, may it please the court. In creating Penal Code Section 43262, the Texas legislature set out to prohibit speech which is neither child pornography or obscenity. And in doing so, they created a bill which is both not narrowly tailored to a compelling government interest and which is overbroad. And I would point out at the beginning that we agree with the state that we are only challenging the specific elements of the crime charged in this particular case. So what we're dealing with in this case would be knowing possession of visual material that depicts the lewd exhibition of the pubic area of a clothed person younger than 18 years of age, and then the next two elements. We're not talking about if you could actually see genitals. We're not talking about any other part of this statute.
Are you talking about clothed or unclothed or free?
Specifically, our indictment is for clothed only. Okay. And so whenever we look at this statute, if you look at the background from the legislative history that's presented to the court, we know that the legislature was specifically concerned with something other than child pornography, which they identified as child erotica. Also, as part of the background, it's important to recognize we already have a strong child pornography statute. We already have obscenity laws. We already have laws about providing obscenity to other children. We have, I think, a Class C misdemeanor law for children who are quote unquote sexting with each other. Okay, so all of that's already outlawed.
What does this add to then? What does this add to, according to the legislative history?
That's a very good question, Your Honor. And that's part of the reason why we're here is I'm not sure that it's abundantly clear. I would point out that under the child pornography statute, the definition for sexual conduct, so anything that is child pornography must have sexual conduct, includes the lewd exhibition of genitals. Something added into this new statute is lewd exhibition of pubic area, and then specifically, as in this case, clothed pubic area. So then we go and we look at the original and introduced version of this law. And what that law included, I now know, I didn't realize this till recently, it basically included what's called the DOS factors. That comes from a Washington, D.C. case from, I believe, late 80s, early 90s. And included in the original bill were things like the child had to be in inappropriate attire considering the age of the child. The focal point of the visual material was the genitalia or pubic area. The setting or pose had to be associated with sexual conduct. The child is depicted in an unnatural pose. The visual material suggests sexual coyness, or the visual material was designed to elicit a sexual response from the viewer. Now, and I would point out that there is also a specific mens rea, just like we have in the child pornography statute, that said the actor had to know that the material depicts the child as described in Section 1. The legislature pulled all of that language out. All of the DOS language was pulled out, as was the specific mens rea. And if you read the complaint or the indictment in Mr. Lowry's case, you'll notice that if you read that in its plain language, the knowledge requirement doesn't go to any of the new elements added into the crime. So then if we look at the statute as written, it's not too clear exactly what's being outlawed. But I think if we combine that we've removed those DOS factors and we've removed that specific intent that we have in the child pornography, we're clearly trying to get two things which might be precursors to child pornography, but that are specifically not child pornography. Yes.
Mr. Landers, would you agree that if ex parte low was about titillating talk, this is kind of like the analog visually? It's like titillating images?
I think that's exactly what's going on here. Is the legislature is attempting to outlaw something which, if we maybe catch it now, will prevent a crime at a different time. Now, we were told in ex parte low specifically that we can't simply outlaw protected speech in order to prevent some future crime or some different crime. That was one of the major background ideas behind the Lowe case. Also, one of the background ideas behind the Free Speech Coalition case at the Supreme Court, which is we're not going to outlaw things that are almost unprotected speech if it's going to prohibit a large amount of protected speech. And I think the first thing the court has to grapple with is this question. Does this law encompass and outlaw things which includes protected speech? I think it's clear that it doesn't only outlaw obscenity. That's because we're missing the second Miller test. Also from, the second Miller prong, which is that it portrays sexual conduct in a patently offensive. Patently offensive. Something else that we're missing here is nothing is saying that we have to take the visual material as a whole, or that we have to apply contemporary standards, our contemporary community standards, which is what we do in obscenity cases. And
and there's no defenses.
Well, and I think that gets to the second part here. Assuming no obscenity and assuming that it outlaws things other than child pornography, it could definitely be more narrowly tailored. So our position is the government has a compelling government interest in protecting children, but this law is simply not narrowly tailored. And some of the things that we've pointed out are they've removed the Miller prongs.
Mr. Landers, I'm sorry. Is there a way that we can construe this narrowly to avoid a constitutional violation? I understand your argument is a little bit different from that, but is there a way we can narrowly construe it?
Well, first off, I think if you read the Thompson opinion from the CCA and even the recent Jones opinion, in this particular circumstance where the legislature, we know, removed that specific mens rea, I believe it would be improper for the courts to read it back in. I also think that because the legislature has taken out all of these DOS elements, I think it would be improper to read those back in. So based on the legislative history, I don't see how the court can go back and rewrite it for the legislature, when in reality what we have, I believe, is just an unworkable law that, protects or outlaws unprotected speech.
Okay, let us hear from the other side, but give us a DOS site when you come back up, please. Are you there, Ms. McLean? I don't see or hear Mrs. McLean.
Good afternoon, Your Honor.
Okay, there you go. Let me ask you a question before we get started.
Yes.
If the fact that there are no defenses, including in 262, but many are included in 2625, how does that affect the analysis of 262 being overbroad? For instance, no law enforcement, school administrator, et cetera, defenses are to possessing or looking at visual material.
Yes, ma'am. Yes, Your Honor. Essentially, that's going to get into the distinction between a scrutiny analysis, which is what's at issue in this case, versus a challenge under the First Amendment overbreadth doctrine, which is a distinct test. It's a different question, and it's one that wasn't raised in the trial court or preserved for this appeal. I'll just jump into that since that's your first question, Your Honor. The First Amendment overbreadth doctrine, what that essentially does is it allows a defendant to get around the standing requirement and argue that even if a law may have legitimate application or a constitutionally permissible sweep, he can still challenge that as unconstitutional because it applies to innocent third parties or to too many third parties. That's essentially what what appellant is arguing when he's complaining about the lack of the affirmative or the defenses for certain innocent actors like law enforcement or school administrators. That is distinct from a claim that a statute by its plain terms is void because it prescribes too much protected speech. In other words, there is no legitimate sweep, there is no legitimate scope because, for example, it's a content-based statute that's not narrowly tailored. That is a separate question. They are distinct doctrines. They are treated differently depending on which challenge you have raised and the type of statute. The burden is even different for the parties. For example, under the overbreadth doctrine, the burden is always on the challenger to show that the statute is overbroad. And that means that its impermissible applications are substantial in relation to its legitimate sweep. Versus, like appellant has argued already for Justice Countess, do you have a question?
Go ahead and finish your sentence, and then I'll have a question.
Thank you. Whereas, as opposed to that, under essentially a strict scrutiny analysis, appellant is absolutely right. If a statute is content-based, the burden is upon the state to show that it's narrowly tailored. And if it does that, it's showing that the sweep is legitimate. And so essentially, when we're talking about a statute that is applying to too many third parties, to too many innocent actors, that falls under the overbreadth doctrine, and appellant did not preserve that. He did not argue that point in the trial court. And specifically in volume 1 of the record on pages 11 and 18 and 19, he specifically repeated, we're just arguing this fails strict scrutiny. Overbreadth was mentioned, but it wasn't specifically described. He didn't describe the legitimate sweep of the statute or meet his burden to show that any impermissible applications are substantial in relation to that legitimate sweep. So any argument under the overbreadth doctrine is not preserved here in this case. The issue here is whether the statute by its terms is prescribing too much protected conduct.
Ms. McLean, so if you'll just, humor me and assume that the overbreadth issue was properly preserved, what is it about the statute that you can point us to that prevents it from being overly broad? Is there an intent element? Is there a time, place, location? I mean, I don't see it, but how would you argue that it's not overly broad?
Right. And Your Honor, I argue it's not overly broad or that it's constitutionally permissible because it is so specific in what we're prescribing. I know appellant has argued that the knowledge, there is assigned to requirement in this statute right before the possession element. And appellant is arguing that that same knowledge or scienter cannot be applied to the contents of the visual materials themselves. But that's an unreasonable reading of the statute. The statute can be reasonably construed to apply that knowledge mens rea both to the fact that one possesses visual materials, but also to what kinds of visual materials those are. Courts do not only have the ability to narrowly construe a statute where reasonable, of course, to prevent a constitutional violation, they also have a duty to do so. And that's laid out in Ex parte Thompson and recently by the Court of Criminal Appeals in Ex parte Jones.
Right, but in Ex parte Jones, the court managed to find that, or to point out that the disclosure, that's the revenge porn statute, right?
Yes, Your Honor.
That it's, that the disclosure has to be intentional with lack of consent, that there's an expectation of privacy. So I guess I'm still trying to figure out in the statute that we're talking about here, what's the limiting language? What can
Yes, Your Honor. And to get to your point, Your Honor, part of the limiting language is the mens rea that should be construed by this court to apply to the types of visual materials we're talking about. In Jones, the Court of Criminal Appeals had no problem implying the intent or the knowledge mens rea to the element of without the depicted person's consent, even though that does not have a specific mens rea attached in front of it. The mens rea element actually comes behind that. That did not stop the Court of Criminal Appeals because they recognize their duty to narrowly construe statutes where they can to avoid potential problems. And so that same, yes, Your Honor.
Yes, Ms. McLean, let me ask you, if I disagree with you that this is just child pornography regulation, how does the statute survive?
Yes, Your Honor, and that actually gets to Justice Countess's point. If this statute is considered to implicate First Amendment speech, not simply child pornography, it is narrowly tailored enough that whatever's going to actually fall under the scope is narrow enough to survive a constitutional challenge. For example, it is limited to visual depictions, not merely writings or drawings or things like that. It's limited to depictions of children under a specified age. They have to be engaged in not just exhibition of a clothed pubic area, for example, children on the beach or people at a swim meet or something like that. This needs to be the lewd exhibition of a child's pubic area, a clothed child. And furthermore, more than that, the statute also requires that those materials have to appeal to the prurient interest in sex, and they can have no serious artistic, political, literary, or scientific value. And with all of those elements together, it makes this statute extremely narrowed and sufficiently tailored enough to achieve the state's compelling interest in this for the statute.
Ms. McLean, if you know, what is the status of the prosecution of Netflix under this chapter?
I do not know. I am not aware. And frankly, it's not really at issue in this case. It's not really instructive here. If, for example, the video of the Netflix movie, if it is found by a trier of fact to have some sort of artistic or political value, then the statute it's doing its job, and that prosecution will end or by acquittal or dismissal. If it doesn't have any of that value, then the statute does what it's supposed to do. So how one statute might apply to this one not hypothetical, but this one Netflix situation, it doesn't change the analysis this court has to undertake. And even assuming, even if appellant had preserved a challenge under the overbreadth doctrine, that is not a single prosecution of the Netflix movie is not sufficient to show that any impermissible application of the statute are substantial in relation to its legitimate sweep.
So has any court held that visual material depicting lewd exhibition of a pubic area of a clothed child is child pornography?
Your Honor, as I cited in my brief, United States v. Knox, I believe it was the Third Circuit, interpreted the federal child pornography statute, and part of their definition involved the lascivious exhibition of the genitals or pubic area of a child. And the court in that case held that that element did not require, you could satisfy that element even though the child's genitals are clothed. So
Well, but doesn't Miller require it to be patently offensive? And they would have used that statute, that case to analyze that?
Miller is dealing with the obscenity statute, and Knox is a child pornography statute. So they are.
Okay, but I'm talking about the patently offensive, which has been eliminated from this particular statute.
Yes, Your Honor.
So I misstated the wrong case.
I'm sorry. So are you asking what the import of the patently offensive, removing that in this statute is?
Right.
Okay. And the reason I think that the legislature might have done that is because there may be, as recognized in Ferber by the Supreme Court, there could be instances or visual materials that do sexually exploit children, but they may not be considered comparable in certain community standards to be patently offensive on their face. For example, maybe images involving 17-year-olds, they may not satisfy the definition of obscenity under Miller. They may not be considered patently offensive, but they are nonetheless exploitive, sexually exploitive of children. And that's part of the whole reason why child pornography has been removed or is made separate from the area of speech of obscenities, because they don't, the obscenity statutes do not adequately serve the state's interest in protecting children from sexual exploitation.
Okay, I'm sorry I talked over you, Judge Landau.
Oh,
Please.
I'm sorry. Did you finish, Chief?
Yes.
Okay. Ms. McLean, I'm not sure I read Knox the same way you do, because child erotica is not a federal offense. In fact, it's a defense to a child pornography prosecution.
And under the, I'm not familiar with the defense that you're talking about, Your Honor.
If you look at any federal case involving child pornography, it is
Yes.
distinguished from child erotica, and child erotica is not part of child pornography. So I'm not sure I read Knox as allowing the prosecution of child erotica under federal law.
And I can't speak to how the federal statutes are defining child erotica. I think some different cases have considered them a little differently. Some describe it as children in sexually suggestive poses. It's just a little bit different. But Knox specifically did involve videos that had children who were in underwear. Their genitals and pubic area were entirely clothed, and they were not discernible through their clothing. And yet Knox upheld and said that they were prosecuted under the child pornography statute. And I know cert was denied in that case. So I may just be missing what you're referring to, and I'll go back and look, Your Honor, for sure. But I know Knox did deal specifically with clothed children whose genitals were not discernible through their clothing. And that was upheld as a prosecution for child pornography that was upheld under the federal statute. There are no other questions? I guess briefly, while I have a few minutes, I want to jump real quick to the vagueness argument. It does incorporate a lot of what we've talked about already, especially with the scienter element that needs to be reasonably construed to apply to the contents of the images themselves. I know that was one of appellant's arguments as to why this statute is unclear. However, the terms of the statute are sufficiently definite. They do give notice of what the prescribed conduct is. They are very clearly worded and very specific. They also prevent arbitrary enforcement by police due to their clear terms. And if this court does determine that the First Amendment is implicated by the statute, it's also sufficiently definite to avoid chilling any protective expression or protected expression because it is so clear what is prescribed.
Ms. McLean, I actually do have a question that I forgot to raise earlier, which is, I guess, really, I'm kind of wanting to know a little bit more about what the evidence is that this statute is going to regulate some sort of conduct that is leading directly to harmful treatment of or exploitation of children. What is the evidence of that?
And I don't suggest that it's leading to the harm of children. It's actually harmful conduct towards children itself that is currently a loophole that was left open by our existing child pornography statute. Children, and it's listed in the legislative history, and I noted it in my brief, is that law enforcement they noticed a loophole whereby actors could possess visual materials that depict children in a sexually explicit manner, but they could not prosecute them under the existing child pornography statute because it did not encompass that same or that type of exploitive conduct. So the specific terms of the statute here, it is limited to conduct or depictions of children. The lewd exhibition of their genitals or pubic area is nonetheless sexually exploitive, whether the children's pubic area is clothed or not. And so it's not really a precursor to anything. It is sexual exploitation of a child, just in a different type of visual material that our current child pornography statute did not prescribe. So essentially the legislature has expanded the definition of child pornography through this statute.
But the evidence is just limited to what you cited in your brief, that law enforcement has indicated that
there are a lot of prosecutions where they find lots of what they're deeming child erotica, i.e. materials that's falling out of the existing child pornography statute, either in combination with child pornographic materials or on their own, so they could not charge before enacting this statute, Yes, Your Honor.
Okay, so is child erotica child pornography?
I'm arguing yes, it is. It under Ferber, when you look at the justification or the reasons behind child pornography statutes, the interests served are the same here, is to prevent sexual harm and exploitation of children. And that can happen whether or not they are clothed or not. The Ferber requires that child pornography statutes be sufficiently described, that they apply to visual representations of children below a specified age, and that they outline the prescribed depictions with very clearly with definite clarity. I apologize, Your Honor.
Okay.
The statute does all of that here. It's limited to visual depictions of children below a specified age. And it makes very plain what specific type of sexual conduct the visual materials at issue cannot contain. And therefore, yes, and my argument that it is essentially an expansion of the state's prescription on child pornography.
Okay, thank you very much.
Thank you.
Let's hear from Mr. Landers again.
You hear me, Judge?
Yes, I can. Please proceed.
First, I'd like to give you that site for DOS. It's
Okay.
636 Federal Supplement 828. I've heard of the case before, but I didn't realize that the elements for mentioned in DOS were the exact elements used in the original version of this law. And I didn't realize until I read Romo versus State from the Fourth Court of Appeals last week, applying those elements. And what's interesting is Justice Landau.
But only as it relates to our statute 260.
No, Your Honor, that case happened to be a child pornography case.
Okay.
So as originally written, it appears that this statute was going to apply to obscene conduct or obscene speech, already not protected, and it was going to clarify that we can use these DOS factors. Well, they clearly took those DOS factors out, and that relates to what Justice Landau was saying in this Knox case, and you'll see it in other cases as well, where you might have clothed children, but specifically, like in Knox, you have them being directed off camera, they're in sexually suggestive poses. It kind of follows these elements from the DOS standards. That's all been removed from this law. That's why this law is hitting on something which is what we would consider protected speech. It could apply to teenagers texting each other completely clothed. It could apply to clearly the Cuties type movie, and it could apply to the I guess Instagram influencers or whatever you call. And apparently there's teenage Instagram influencers as well. I would point out that not only did we brief the void for vagueness, due process, and First Amendment argument that includes overbreadth, I actually argued that at page 8 of the first reporter's record. I also specifically asked for the judge to make a ruling on that issue. I don't see how that would not be preserved for appeal. And what's interesting here is that overbreadth doctrine, the fact that this law outlaws a broad swath of speech, which is protected speech, is also part of the reason why this is an overbroad law. And it's part of the reason why it's not narrowly tailored. Okay. So whenever you read these cases, and you'll read them from the Supreme Court, you'll read Ex parte Low, you'll see that oftentimes the courts are considering these two facial challenges together. And part of the, we believe it is overbroad here, which is a violation of the First Amendment, and we've provided reasons why. But part of the reason it's not narrowly tailored is also because it's not really clear what's being outlawed. I can tell the court is having problems just as I have. And the more I read the law and the more I read child pornography cases, the more confused I become. And under overbreadth, that's part of why it makes us steer clear of certain conduct, because we don't want to be in violation of the law. And Judge Raddick, you pointed out a very good point. The fact that we don't have these exceptions or these defenses is another reason why this law is not narrowly tailored to protecting children. Luckily, my child is only 7 years old, so I'm not dealing with this yet. But I think we all recognize, and as a matter of fact, the Supreme Court recognized in the Free Speech Coalition case that in our society, we recognize that 17-year-olds are going to have some sort of sexual expression. And I guess that's what we're trying to outlaw here. But the bottom line is it goes too far. And the fact that we don't have that 2-year age limitation here, it really opens up a lot of our high schoolers to prosecution. Now, would it happen? I don't know if it would happen. But the Supreme Court has always been clear that just because the government tells us they're not going to prosecute police or children or teachers, that doesn't solve these problems. And then I would like to address the scienter requirement again. I have read that Jones case from, I think, last week or the week before. That statute is very different from our statute. Not only does it include a scienter requirement that was read backwards, which is a little strange, but it also was based on reasonableness on the part of the defendant. And the Court of Criminal Appeals discussed that reasonableness element necessarily includes the defendant knowing he shouldn't be doing these things and still doing it. It also, the video in that case had to be disseminated in a way where the defendant knew that whoever was videotaped thought it would be private. All right, so that law is very different from the law we have here. And I would point out, if the court goes to read our indictment in this case, it appears that originally the prosecution read it the same way that I read this, which is knowing only goes to the possession of the photograph, not to other things. So if there's no further questions, I would just point out that we do think this law is both not narrowly tailored and overbroad. We would request the court find section 4262 of the Penal Code unconstitutional. Thank you.
Are there any questions? Okay, thank you both for your arguments. The court is adjourned.